while representing yourself in court? That's called pro se representation, and judges usually hate it. Why? Because you're up against trained prosecutors who know every trick in the book. Would you ever perform surgery on yourself? Exactly. That's how risky this is.
I will be playing non-guilty today, and I will be representing myself.
Okay, there's a certain way we go through things. Just bear with me a second. So the first thing is that you're charged with failure to stop and give information. You're facing up to 6 months in jail and or 2,000. I know that you're ready to say, go through your list of this and that, but because you want to talk, you're not listening. I need you to listen for a second. I'll give you time to talk, I promise. Just let me get through the spiel and then I'll give you an opportunity, okay? You're charged with failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay, we're just going to do probable cause because I don't know what happened. Maybe there's no probable cause and then you're out of here. I don't know. Stop. You have the right to remain silent. Exercise that. They're DAs. Every single thing you say, they're going to sit there and type to use you.
I know that's my right.
Just hold on. Let's do probable cause first. Okay.
Yes, Judge. On June 15th, 2024, officers were dispatched to a crash. They met with the complainant who reported that she was involved in a crash with a Toyota Tundra and provided the license plate number. The male with gray shorts, no shirt, and tattoos stepped out of his vehicle and offered the complainant to follow him back to his house, and the complainant declined the offer. The defendant then left the scene without giving any information and sideswiped the complainant's vehicle a second time. The officers began to head to the car's registered address, 0.4 miles away, when they received a second call for help.
And there it is, the golden phrase, admitted to driving and leaving the scene. That's basically a confession. In legal terms, this makes probable cause almost a guaranteed checkmark for the judge. But what do you think should someone's mental state at the time erase responsibility for a hitandron?
At the address they were headed to. At the address, a male matching the description provided by the complainant was having a mental episode in front of his house. The defendant admitted to driving and leaving the scene without giving information. The damage was approximately $2,000.
Okay. All right, Mr. Peeler, I'm going to find that there's probable cause to go forward with your case. How old are you, sir?
So on June 15th, I was in a state of psychosis, and I have documentation of the settlement that took place for the liability property damage which occurred on that incident. I have the claim number in front of me if you need it, Your Honor, for that settlement. I have the mental health crisis documentation discharge summary provided by the Harris County Constable living at 13800 Lake Superior Lane if you need that. Upon further request, I can provide documentation of the discharge from the hospital that I went to.
Let's do this.
Supporting the mental health.
Mr. Peeler.
And I'm disabled. So.
Let's do this. Why don't I have you talk to a lawyer? Okay. Your lawyer can talk with you, get to know you, find out what happened, and then they can approach the state to try to, see what's going on.
But I'm disabled and I don't want to be, and I never was.
Just don't say anything.
Warrant at all. I never received anything in the mail, not once. So how can
sometimes cases work like that. Sometimes a person is involved in some kind of situation where a warrant will not issue immediately to where they get.
Notice how the judge is pressing pause here. Instead of letting this defendant keep talking himself deeper into trouble, he's hitting the brakes and bringing in a lawyer. Smart move. In fact, judges often do this to protect both the case record and the defendant from self-sabotage. Audience question: do you think the judge is being protective? Or just tired of the rambling?
Taken into custody at that time.
Well,
those are called
in the mail, so I assumed that I would have received something.
Never assume anything.
You're right.
Never assume anything. But let's do this. I can have you talk to a lawyer here momentarily. You can explain your situation to the lawyer. The lawyers can talk to the DA, and then we can work something. Okay.
So
just hold on.
I agree.
I don't want you to say anything because there are a bunch of DAs here, and everything you say, they're going to use it against you. I will give you the opportunity, but first let me have you talk to a lawyer. I've got a bunch of them and they're great. They truly will help you out. Okay, really. Yeah, so let's do this. I'm gonna have you go to Victoria, sign and reset. I'm just gonna have you take a seat in the jury box while I find your lawyer. Be patient though. I've got 150 people here, Mr. Peeler, okay? So just be patient, okay?
failure to, well, I actually did stop. I mean, for the record, we both exchanged words outside our vehicle.